All right, so let's dive into something. Well, something that's like woven into the very fabric of our justice system. Something we hear about all the time, but maybe don't always fully grasp. The Eighth Amendment's ban on cruel and unusual punishment. Think
hmm
about it. What exactly does that mean?
hmm
And how has our understanding of it changed over time? That's what we're unpacking today.
Yeah, and what's fascinating is how those three little words, cruel and unusual, have had like a monumental impact on how we view justice and human rights in this country. It's a journey that takes us through centuries of legal battles, societal shifts, and some really thought-provoking questions about who we are as a nation.
Absolutely, and we're talking about a concept that shaped everything from the death penalty to how we treat prisoners to really wrap our heads around it. I think we need to go back, way back, to a time when punishments were, well, let's just say a bit more intense.
Right. Imagine England in 1685, a time of simmering religious tensions and outright rebellion against King James II. His own nephew led this uprising, and after it was crushed, the punishments meted out were truly brutal. We're talking drawing and quartering, folks being shipped off to the West Indies as indentured servants, essentially a life of slavery.
Wow. Yeah, it paints a pretty grim picture, right?
hmm
This period, known as the Bloody Assizes, was a turning point. It led directly to the English Bill of Rights in 1689, which for the first time put a legal stop to cruel and unusual punishments. That document became the bedrock for our own Eighth Amendment more than a century later.
Yeah, it's a direct line from those brutal 17th century punishments to the rights we hold dear today. And what's interesting is that around the same time, across the English Channel, a revolution in thought was brewing the Enlightenment. One figure who really shook things up was Cesare Beccaria, an Italian philosopher who was vehemently against torture and the death penalty.
And his book, On Crimes and Punishments, was basically a bombshell in the intellectual circles of the day. He argued for something that seems pretty obvious now but was radical back then. The idea that punishment should fit the crime. It needed to be proportional.
Right, and here's where it gets really interesting. The American founding fathers, guys like Washington, Madison, Jefferson, Franklin, they were deeply influenced by Beccaria's ideas. They soaked it up. These were men of the Enlightenment, and Beccaria's emphasis on reason and human dignity resonated with them.
So fast forward to the drafting of the Eighth Amendment. They were inspired by the English Bill of Rights and state constitutions that already included similar protections. But here's the key. They purposely left the language a bit open-ended.
Yeah, they knew that societies change, and they wanted the interpretation of cruel and unusual to evolve with those changing values. They weren't trying to create a rigid list of what was and wasn't permissible. They were establishing a principle that could adapt to future circumstances.
It's like they built in this flexibility, knowing that what might seem barbaric in one era could be commonplace in another. And even back then, there was debate among the Founding Fathers about what this amendment really meant. One representative, Samuel Livermore, even argued that it had no meaning because it wasn't specific enough.
Exactly. Livermore wanted to know if things like whipping or cutting off ears would still be allowed. It just goes to show how much our standards of punishment have changed and how important that flexibility was. They understood that they couldn't predict every situation, and they wanted to leave room for the courts to interpret the amendment as society progressed.
So for about a century after the Eighth Amendment was ratified, things were relatively quiet on the legal front. But then, in 1910, a case called Weems v. United States really shook things up
Okay.
and put this whole idea of evolving standards of decency to the test.
This case involved a guy named Paul Weems, who was working as a U.S. postal worker in the Philippines, which was a U.S. territory at the time. He got caught falsifying some official records, not exactly a violent crime. But the punishment he received, well, let's just say it wasn't a slap on the wrist. Weems was sentenced to 15 years of hard labor, chained at the wrists and ankles. On top of that, he lost all his civil rights for life. This punishment, called cadena, was totally standard in the Philippines back then. But the Supreme Court was having none of it.
Wow, so what happened?
They ruled that this punishment was way too harsh for the crime, and it had no place in a system based on American law. This is where the Supreme Court really fleshed out that concept of evolving standards of decency. They basically said that what's considered cruel and unusual punishment isn't set in stone. It changes as society progresses.
So even though cadena might have been considered normal a century earlier, the court recognized that American society had moved beyond that. And this idea of evolving standards gets reinforced again in 1958 with another landmark case, Trupp v. Dulles. This one dealt with a U.S. soldier who deserted during wartime.
Now, desertion is obviously a serious offense, but The punishment in question was stripping this soldier of his U.S. citizenship. The Supreme Court stepped in and said, nope, that's cruel and unusual. They argued that citizenship is fundamental to a person's identity and their very existence in society. Taking it away is like cutting them off at the roots.
So they saw that as a very serious punishment.
Yeah. They even said it was a fate potentially worse than death, which really highlights how the court was expanding its interpretation of the Eighth Amendment. It wasn't just about physical pain anymore. It was about protecting a person's dignity and basic rights.
That makes sense.
These two cases, Weems and Trop, really set the stage for how we understand the Eighth Amendment today. It's not about specific punishments, but about broader principles of fairness and human dignity. And nowhere is this more apparent than in the debate over the death penalty.
Oh, yeah. That's a big one.
In the 1960s, as the civil rights movement was gaining momentum, activists started challenging the death penalty on Eighth Amendment grounds. They pointed out that it was being applied unevenly, with Black defendants in the South far more likely to receive a death sentence than white defendants. It was a powerful argument for racial justice.
And it seems like that would have been pretty hard to ignore.
It was. Lawyers with the NAACP launched this massive campaign, sending teams down south to gather data, poring over court records to show the stark racial disparities. They presented this evidence to the Supreme Court. In a series of cases, collectively known as Furman v. Georgia, their argument was that the death penalty, as it was being practiced, was cruel and unusual punishment because it was arbitrary and discriminatory.
So what did the Supreme Court say?
And in a landmark decision in 1972, the court actually agreed. It effectively abolished the death penalty nationwide, which was a monumental moment in legal history.
Wow, so that was it. The death penalty was gone.
Well, not so fast. What's really fascinating is that there wasn't a single clear-cut reason for the decision. All 9 justices wrote separate opinions. It was incredibly rare to see such a divided court on such a major issue.
So they all agreed on the outcome, but not necessarily on the reasoning.
Exactly. It was a mix of different arguments. Some justices believed the death penalty was inherently unconstitutional, while others focused on its inconsistent application. One justice even called the system pregnant with discrimination.
Strong words.
But 2 justices, Stewart and White, offered a particularly striking analogy. They compared being sentenced to death under those conditions to being struck by lightning, totally random and unpredictable.
Yeah, that's a pretty powerful image.
They said the lack of clear guidelines for juries was allowing bias to creep in, which led to wildly different outcomes depending on where a trial was held and who was on the jury. This idea of arbitrariness was key. It wasn't about the death penalty itself being inherently cruel, but about the system being so unfair and unpredictable that it violated the Eighth Amendment.
So the way it was being applied, not the death penalty itself.
Yeah, right.
So the death penalty was effectively out, at least for a few years. But I have a feeling the story didn't end there.
You got it. The Furman decision caused a massive backlash, especially among those who supported capital punishment.
Oh, I can imagine.
Think about it. Suddenly, everyone on death row across the country had their sentence reduced to life in prison. That included notorious figures like Charles Manson and Sirhan, Robert Kennedy's assassin. Public opinion started to shift. And within just 4 years, 35 states, along with the federal government, had passed new death penalty laws. They were determined to bring it back.
So they weren't going to just let it go.
Yep.
So what did these new laws look like?
These new laws aimed to address the concerns raised in Furman. They introduced stricter guidelines for juries, requiring them to consider mitigating factors, like a defendant's background or mental state, before handing down a death sentence.
So they were trying to make it less arbitrary. The big question is, did these new laws fix the problems that the Supreme Court had identified in Furman?
Well, in 1976, a series of cases challenging these new death penalty laws landed back at the Supreme Court, and the court's response was, well, complicated.
So not a simple yes or no answer?
Right. They upheld some of the new laws, specifically those from Georgia, Florida, and Texas. These laws provided more guidance for juries, aiming for more consistent and less arbitrary sentencing. But the court also struck down death penalty laws from North Carolina and Louisiana because they mandated automatic death sentences for certain crimes, which went against the whole idea of individualized consideration that the court had emphasized in Furman.
So it was a mixed bag.
It was.
But they were still trying to make it more fair.
Exactly. The court was very clear, no more automatic death sentences. Juries absolutely had to have the discretion to consider the individual circumstances of each case. And any factors that might mitigate the severity of the crime. They stressed the need to recognize the diverse frailties of humankind, as they put it so eloquently.
So it sounds like the court was trying to strike a balance there.
Yeah, they were trying to find that middle ground. So the death penalty itself wasn't deemed unconstitutional, but the court made it much, much harder to impose. This marked a turning point. It set a precedent for narrowing the scope of the death penalty. Over the following decades, the court would rule against executing juveniles, people with intellectual disabilities, and those convicted of crimes like rape where a murder didn't occur.
So they kept refining those standards. And it's interesting how the Furman decision and its aftermath really show how the Eighth Amendment isn't just some static rule. It's a principle that's constantly being interpreted and reinterpreted in light of societal values and legal arguments. We see this continuing today with debates over issues like solitary confinement.
That's a great point. What might have been considered acceptable punishment a few decades ago might be viewed very differently today. Solitary confinement is a prime example. Some people argue it's a necessary tool for managing dangerous prisoners, keeping correctional officers and other inmates safe. But critics say it amounts to torture, causing severe psychological harm, especially when it's used for prolonged periods.
And it's not just limited to what happens inside prisons. We're also seeing these debates play out in how we deal with issues like homelessness. There are laws in some cities that essentially criminalize homelessness, making it illegal to sleep or even sit on public property.
These laws raise serious Eighth Amendment concerns. Critics argue they're essentially punishing people for being poor, for having nowhere else to go. It's a complex issue. But it highlights how the Eighth Amendment is still relevant in these broader societal contexts, prompting us to examine how we treat the most vulnerable among us.
It seems like there's this constant push and pull between those who advocate for harsher punishments and those who are calling for more humane approaches. Where do you see this whole debate over cruel and unusual punishment heading in the future?
Well, one thing's for sure, the Eighth Amendment isn't going anywhere. It's woven into the fabric of our legal system. But how it's interpreted, how we define cruel and unusual, that's always going to be an evolving conversation. We're seeing a growing movement to abolish the death penalty entirely. And there's increasing scrutiny of practices like solitary confinement.
And as you mentioned earlier, there's this growing awareness of how poverty and homelessness are treated as crimes in some places. Do you think these issues will be at the forefront of Eighth Amendment challenges in the coming years?
Absolutely. As we grapple with issues like mass incarceration, racial disparities in the justice system, and the criminalization of poverty, the Eighth Amendment is going to be a crucial tool for advocates and legal scholars who are pushing for reform.
It really all comes back to those evolving standards of decency. What we consider cruel and unusual today might have been perfectly acceptable a century ago, or even just a few decades ago.
That's the heart of it, isn't it? We're constantly reassessing what constitutes a just and humane society. The Eighth Amendment compels us to have those difficult conversations and to keep challenging our assumptions about punishment and justice.
So for our listeners out there, what's one key takeaway you hope they walk away with from this deep dive into the Eighth Amendment?
I'd say it's this. The Eighth Amendment isn't just some abstract legal concept. It's a reflection of who we are as a society and what we value. It's a call to constantly examine our practices, to make sure our justice system is truly just, and to ensure that we're treating all people with dignity and respect, even those who have broken the law.
Well said. This has been an incredibly insightful journey through the history and evolution of the Eighth Amendment. It's a reminder that the fight for a more just and humane society is an ongoing process, and it's one that we all have a role to play in. Thanks for joining us on this deep dive.